morning, everyone. I am Carol Williams with Williams Immigration, and this is another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. Usually I like to keep things to the past week, but as we know, immigration takes a little bit longer to do things. So oftentimes we talk about things that are beyond what has happened with U.S. immigration this past week. So, I like to dive right in. The first thing I want to talk about, which should be of no surprise to anyone that has been watching me all this time, is the H-1B lottery season. We are still in it, but we are at the tail end, assuming they don't run another lottery, but we are at the tail end. So if you were selected in the H-1B lottery back at the end of March, beginning of April, those applications are now due June 30th, which is this Friday. So keep that in mind. We're on the home stretch getting those last applications filed, but they are due to the Service Center, USCIS, by June 30th, which is this Friday. So we are in the home stretch of the H-1B cap season for this year. The second thing I want to talk to y'all about is premium processing for students. Over the last few months, we have seen USCIS taking a role that they are increasing the types of applications that are eligible for premium processing. Premium processing is an expedited way of having your application processed with the Immigration Service. So now they have opened up premium processing, as they said they would, to students. So those individuals that are in F1, M1, M2, J1s and their dependents, they are now eligible for premium processing. So if you already have a change of status request for a student status in with the Immigration Service, if it's already pending, if you've already filed it, you are now eligible to upgrade that application to premium processing by filing the Form 907 with the agency, the appropriate fee, and then that will get them moving and grooving and processing your application much quicker than the current processing times. If you have not filed your application yet, good news, beginning today, June 26th, they are accepting newly filed change of status applications to, again, F1, F2, M1, M2, J1, or J2. So a few things to remember. If your application is already pending and you are upgrading your application, if you filed online, then you must file your premium processing request online. If you filed using the paper, then you will need to file your 907 via paper. So you do not want to crisscross your modalities of filing. So if you filed online, they will not accept your 907 via paper. So just keep that in mind. The other thing is that your premium processing clock does not start until USCIS has received your biometrics. So you want to be very diligent in checking your mail and going to those biometric appointments. So just keep that in mind. It's not going to be sort of the regular premium processing where it's a certain number of days from the day USCIS receives that premium processing request. It's going to start, your clock starts after USCIS has received your biometrics. So keep that in mind if your application will need biometrics. If you need help with this, feel free to reach out to our office, 954-903-1337. We are happy to help you. I want to remind everybody that basically in Q1, USCIS said a few things. We're going to kind of go through a couple things. They said that they were looking to increase the filing fees. They published a proposed rule. They put it out for comment from the public. They are now still reviewing those comments. I think this rule is coming. So just keep that in mind. If you are sort of on the fence or you're waiting, taking a wait and see approach, don't wait too long, because once the fees go up, you're not going to be eligible for the old fees. And so fees are going up generally across the board from 99% of the visa categories. So just keep that in mind that is still lurking in the background and we are still waiting for that. The other thing that we heard from the USCIS in the first quarter of this year was that they were looking at a program where they were going to start off small, so kind of H's and L's, non-immigrants, were going to be able to get a new visa without having to go travel all the way home to their home country and now wait for what some countries are incredibly long visa lines in order to get a new visa to re-enter the US in that non-immigrant status. So we are still waiting for that. Hopefully we will see that soon. But they announced that in Q1. We are now heading into Q3 very shortly in a few days, and we haven't seen that implemented. So hopefully we will see that implemented soon. And when it is, I will talk about it on our Monday morning chats together. The other thing I really want to talk about with you guys this morning is Florida Senate Bill 1718 that is set to go into effect on Saturday, July 1 of this year. So again, Saturday, July 1, 2023. Now, this rule really only applies to Florida, but it has some really heavy implications for both employers and employees who hire foreign nationals as well as the foreign nationals themselves. So as a reminder, we all know I've talked about this, but I'm still going to keep talking about it. As of July 1, employers that have 25 or more employees are going to have to begin using E-Verify. E-Verify is a government database that helps an employer determine whether or not an employee is eligible to work in the United States. So E-Verify pings the Social Security Administration database as well as the DHS or Department of Homeland Security database. So it confirms work authorization. And there is a process that employers must go through if that work authorization is not confirmed. So if they have a name that may not match with a social security number, or they have a name that may not be pinging in the DHS system as having work authorization, there are ways and there are processes that employers must go through in order to solve these discrepancies or attempt to solve these discrepancies with the employee. So that is a system that all Florida employers, 25 employees or more as of Saturday, July 1, 2023, will need to be using. If you are not quite sure how to use E-Verify, you're not quite sure what that means for your business, you've got foreign nationals on staff, you're not quite sure who needs to be put through E-Verify, feel free to reach out to our office, 954-903-1337, and we are happy to help you get up and running with E-Verify and sort of get on that path so that you are doing it properly and you understand what you should be doing and what you should not be doing by using E-Verify. The other thing the other piece of the Senate Bill 1718 that I wanted to talk about are driver's licenses. So Florida, as of July 1st, 2023, will no longer recognize a driver's license that was lawfully issued in another state to an individual who is undocumented. So again, as of Saturday, July 1, 2023, the state of Florida will no longer recognize a lawfully issued driver's license from another state if that state issued a driver's license to an individual that is undocumented. Doesn't matter, according to SB 1718, that driver's license in another state was lawfully issued under their state rules. This Senate bill in Florida, effective July 1, is saying that Florida will not recognize that. So you want to be aware of that if you are an employer and you are doing the I-9s, if you are doing E-Verify, if you are using the driver's license, for anything. So that is something that we will be obviously monitoring very, very carefully, and we will give you more updates as the time moves forward. The last thing I want to talk about this morning is another national interest waiver tip. So we know that national interest waiver is a green card category. The requirements are, there are really three requirements. It is a national interest waiver is a preference category. So it's in the second preference category, which means that second preference is for individuals that have a master's degree or higher. So in addition to that, the job that you want to come into the United States to do must be both a substantial merit and of national importance to the United States. Second, you as the individual must be well positioned to continue in this role, in this specific job, in this niche, in this industry once you receive your green card. And third, on balance, the US needs to see where it is beneficial for them to waive the normal requirements of one, a job offer, and two, a labor certification application, which is a very fancy way of saying testing the labor market and recruiting for eligible US citizens. So those are the three main criteria for a national interest waiver. Those three criteria are so broadly written, it allows a lot of flexibility, which is the tip for today for national interest waiver. We have such an amazing amount of flexibility when it comes to drafting and showing the Immigration Service that you meet these requirements, that what you're going to be doing will have a substantial impact in the United States, that you have a plan to keep moving forward, and that it's in the US's best interest to give you a green card. So it really allows me and my team to really think outside the box when we are strategizing these cases, which is something that we absolutely love to do. There isn't a specific list of evidence, there's not a specific list of documents that are needed for a national interest waiver, which again allows for more flexibility when we are building and crafting and drafting our cases and getting them ready to go. And it really allows us to really dig in with you and see what you're doing and how what you are doing meets those criteria. So some people think the broadness is just really difficult to deal with. I love it. It really allows me and my team to really get together with a client and be really creative and really find the best way to describe what they're going to be doing and show the Immigration Service by being descriptive, but also providing relevant documentation. So we know national interest waiver requires a lot of documentation, but it really allows us to get really creative. So they're really fun for us to do. So if you have any questions about a national interest waiver, whether or not you qualify, if it's something that you're interested in learning more about, you are welcome to give us a call at 954-903-1337. We will absolutely get you set up for a consultation. And that, my friends, is all I have this lovely Monday morning. Have a great Monday morning and a fabulous rest of your week. And I will be back next Monday with another edition of Beyond